Rules and theory of contract law. Contract law is the area of law that governs legally binding agreements between parties and sets out how contracts are formed, enforced, and remedied when breached. Rules of contract law. The rules of the law of contract are the parties to the contract, the burden of proof, sources of contract law, remedies, and consumer protection. The parties to the contract are the individuals or organizations who enter into a legally binding agreement, and they must have legal capacity and intention to be bound. This rule ensures that only valid parties can create enforceable contractual obligations. It also prevents contracts being enforced against those who lack capacity, such as minors in certain situations. The burden of proof is the responsibility placed on the claimant to prove that a valid contract exists and that it has been breached. This rule ensures fairness by requiring evidence before liability is imposed. It protects defendants from unproven or unjustified claims. Sources of contract law are the legal origins from which contract rules are derived, mainly case law and legislation. Case law develops principles through judicial decisions, while legislation provides statutory rules such as those protecting consumers. Together, they create a consistent and evolving framework for contract law. Remedies are the legal solutions available when a contract has been breached, such as damages or specific performance. Their purpose is to place the injured party in the position they would have been in had the contract been performed. This rule reinforces the binding nature of contractual obligations. Consumer protection refers to laws that safeguard consumers from unfair contract terms and practices. These rules recognize that consumers often have less bargaining power than businesses. As a result, the law intervenes to promote fairness and transparency. Theories of contract law. The theories around the law of contract are freedom of contract, acting on good faith, balancing interests and justice, the principle of fault, and inequality of bargaining power. Freedom of contract is the theory that parties should be free to negotiate and agree on their own contractual terms without interference. It reflects individual autonomy and market efficiency. However, it may be limited where agreements cause unfairness or harm. Acting on good faith is the idea that parties should behave honestly and fairly when forming and performing contracts. This theory promotes trust and cooperation between contracting parties. It challenges purely self-interested behavior in contractual relationships. Balancing interests and justice is the theory that contract law should fairly balance the rights of both parties. It aims to ensure outcomes are morally just rather than strictly legalistic. This theory supports judicial intervention where strict rules cause unfair results. The principle of fault is the idea that liability for breach of contract should be based on blameworthy behavior. It suggests that responsibility should arise where a party has failed to meet agreed obligations. This theory links contract law to concepts of accountability and responsibility. Inequality of bargaining power is the theory that parties do not always negotiate contracts on equal terms. It recognizes that stronger parties may exploit weaker ones, such as consumers or employees. This theory justifies legal protection and regulation to reduce unfairness. Thank you for watching this video on the rules and theory of the law of contract. I'll see you in the next one.